I would like to open the Tuesday, July 28th, 2015 public hearing on the Oakley co-housing city file number PDT 13-1. This agenda item involves a hearing on a remand from LUBA of the Planning Commission's previous approval of the Oakley co-housing PUD. Briefly, an individual, Simon Troutman, failed to receive notice of the hearing's official decision or the Planning Commission appeal hearing when the PUD was first processed by the city. Accordingly, the hearing tonight is to remedy that error and allow Mr. Troutman to testify on the issues raised in the initial local appeal of the hearing's official's decision. Pursuant to state and local procedural rules, the applicant must also have an opportunity to rebut Mr. Troutman's testimony. Before we begin, legal counsel will provide us a brief summary explaining the scope and limitations of the hearing. This agenda item is quasi-judicial in nature, so we will use quasi-judicial format for this public hearing. And do any commissioners need to disclose any conflicts of interest, ex parte contacts, or biases, abstentions, or challenges to impartiality pursuant to Eugene Code EC 9.7056? Commissioner Nicolello.
My term as a Planning Commissioner began on July 6, 2015, and while not present at the Planning Commission public hearing held on December 5, 2013, nor at the deliberations held on December 9, 2013 and December 16, 2013, I have watched the webcast for both the public hearing and the two deliberation sessions. I have also reviewed the public record in full. In full disclosure, I read about this project in the Register Guard prior to beginning my term as a Planning Commissioner. Additionally, I serve on the Board of Directors for Betty Eugene Springfield Transit and am a Projects Coordinator at the Sustainable Cities Initiative. Dr. Robert Zako is a Research Associate at the Sustainable Cities Initiative, as well as the Executive Director of Betty Eugene Springfield Transit. He and his wife, Kathleen Hanna, expressed interest in Oakley Meadows co-housing, and his wife wrote a letter of support, which is in the public record. Additionally, Shane McRhodes also serves with me on the board of Betty Eugene Springfield Transit. He wrote a letter of support for Oakley Meadows, which is also in the public record. Finally, John Belcher, co-chair of the River Road Community Organization, serves on the Board of Advisors for Betty Eugene Springfield Transit. He has written letters on behalf of the River Road Community Organization, which are in the public record. I have not engaged in any ex parte communication with any of these individuals and just wanted to disclose that.
Thank you. And I also need to disclose that I am currently working on a small housing project with the architect for Oakley co-housing, Will Dixon. We have not discussed this project at all, and we've been very careful not to do that. And so I just wanted to put that out there also. Any other? Okay. Do any commissioners have information to share based on visits to the site? Okay. Generally, when the Planning Commission conducts public hearings, we use request to speak forms. However, because this hearing is limited to testimony by Simon Troutman and the applicant, we will dispense with that formality. We will now ask the city attorney to explain the rationale for the limited scope of the hearing.
Thank you. So notice went out for this hearing. Staff wrote an AIS, and I, as the city attorney, wrote a legal memo explaining the scope of what this hearing is. So some of this will be repetitious for some people, but I wanted to say it for the public and for the benefit of the Planning Commission. What happened in this case was at least one individual failed to get notice of the original hearing's official decision in this case, which was issued now 2 years ago or so. He also didn't get notice of the Planning Commission hearing on appeal, so he was not able to attend the Planning Commission hearing. So the case eventually went up to LUBA on a number of issues, and it's been sent back. One of the issues that it was sent back on was to allow Mr. Troutman to testify in front of the Planning Commission, basically remedying the error that was made originally. So that's important to keep in mind, that that is the error that we're trying to remedy in this remand hearing. So that is the purpose of some of the limited scope of this hearing, which is first limited to the issues raised in the original notice of appeal. Mr. Troutman was given an opportunity to file his own separate notice of appeal, chose not to. So this is basically his appeal based on the original notice of appeal. So the appeal testimony today should be limited to that original notice of appeal, which was given to you as part of the AIS, I believe. Also, the hearing, as the chair mentioned, is limited to Mr. Troutman, who is the person who was prejudiced by the error, and to the applicant. The reason the applicant is also testifying is that if there's testimony by Mr. Troutman, the applicant, who has the burden of proof, has to be able to respond to that testimony. And finally, this hearing is limited to the record that was created before the hearings officer. And the reason for that is that we're trying to put Mr. Troutman back in the position that he would have been if he had testified when he was supposed to be able to testify. And the people who testified in the original local appeal hearing before the Planning Commission were limited to the record before the hearings officer. So that's the rationale for why we're doing that. So there shouldn't be any new evidence presented today. There should be arguments based on the issues that were raised previously. I do need to note that today there was a request to take official notice of certain documents. Most of those documents are what appears in here. You received the email that included all those attachments. They are what we refer to as the LUBA record. So the briefing that occurred at LUBA. In general, the code has provision that says you can take official notice of any public document. That's pretty broad, and legal counsel has advised Planning Commission on that provision before. Because your review is generally limited to the record, it's within your discretion of whether to take official notice of certain things. There are some documents in the briefing before LUBA that are things that are outside the record. They were stricken by LUBA because they were outside the record. So after this evening, I will be writing a memo explaining to you which of those documents are likely outside the record, and you would be urged anyway to reject those things that are new evidence. And as I go through this, please.
Yeah, I was going to ask, is it council's recommendation that we take official notice of those documents?
The LUBA briefing itself is not that problematic. The applicant may or may not oppose that. The arguments in the brief aren't really considered new evidence, but there are certain documents that were attached to the briefs, and legal counsel's advice would be to reject those. So you do have discretion to accept the briefing, or you have discretion to reject it if you want to.
Okay. And I guess another question
Yep.
that I would have is, as we go through testimony tonight, just because of the volume of the record, how can we determine, as people, or either Mr. Troutman
Right, good
or
point. So
the
I was
applicant
going to mention,
testifying, how we'll know if that's something in or out of the record, kind of on the fly?
So as testimony comes in, there may be, I mean, it appears that there may be some new evidence that might come in. My advice to you is to go ahead and listen and not interject and interrupt the people participating. And then after the fact, we will read through and figure out what is new evidence and what isn't, and then you will be able to either reject it or accept it.
Okay.
You should note, however, if there is new evidence, if you decide to take in new evidence from either party, the other party needs to have a chance to rebut that. So that's the problem with introducing new evidence, is it creates this opportunity requirement that you continue to open up the record for the other side to respond.
Yeah. Okay. But we don't need to open the record or take new evidence.
Correct.
Okay. Other questions from commissioners? Commissioner Baker. And be sure and speak into the microphone, too.
I just had
Microphone.
I just had a question on the page 2, second paragraph.
What page, what are you referring to?
Page 2, second paragraph of the PC agenda,
Oh, okay.
where it talks about on appeal to the Court of Appeals, the court determined that LUBA should have allowed Mr. Troutman to participate as a party before LUBA. LUBA then remanded the matter to the city to provide Mr. Troutman a notice that it should have provided in the first instance. The city has since provided that required notice to Mr. Troutman. And then on the page before, it says, in the last paragraph, it says, at the time it was discovered that several individuals who had not submitted testimony to the hearings official had not received notice of the hearings official's decision or the Planning Commission appeal hearing.
Right. Do you want to ask the question, or do you want me to
Well,
anticipate what the
maybe you
question
can
is?
elaborate.
Yeah.
Okay.
So there
Yes.
were
We have several mentioned here, and we have only one mentioned in the...
Right, so there were several, I don't know how many, individuals there were who were omitted from the notice. None of those individuals challenged at LUBA that failure. So the remand is to remedy the substantial prejudice that occurred to Mr. Troutman, because he's the one who objected to that at LUBA. So our position is that whoever those individuals might be, they don't have standing because they didn't make that challenge and complain that their rights were prejudiced before LUBA.
Do they have to at least be noticed about this hearing?
They were.
Okay, that's why I was curious.
Yep.
Because it said required notice, it only implies that you noticed Mr. Troutman, that's all.
Okay, yes.
Okay.
Okay. All right. And I think the only other item that I think we need to discuss, and maybe I think this might be the appropriate time to do that, would be the time limits. I know typically in a public hearing of this nature, the applicant, we give 15 minutes, and people responding or testifying, we give 3 minutes. And I guess I'm curious if commission has a preference. I don't know if Mr. Troutman is here. I haven't received anything, to that nature. But Commissioner Borowski.
Well, after receiving the appeal testimony that was entered into the record this afternoon, I think it's a 58-page document with about 1,000 pages of exhibits. I think that if the applicant needs more than 15 minutes, I think it would be appropriate.
Be Mr. Troutman.
No,
Oh, if the applicant needs.
Yeah.
Okay.
Or either one. I think that considering what I've seen in the record, there are quite a few things that have been brought up, and I don't know if the applicant or the appellant would have an opportunity to address those in 15 minutes. So I would encourage a longer time period and base that on whatever
Okay.
the
How do you feel about
30.
Okay, 30? And then Mr. Troutman, would we?
I don't think Mr. Troutman submitted a
Okay.
request to speak for him, so I think his all came in the
Okay.
record.
Is Mr. Troutman here, or his representation?
No.
Okay. So I guess maybe that answers that question. Okay.
Okay.
All right. Well, what's the commission's pleasure, I guess, as far as the applicant's time?
I move 30 minutes, up to 30 minutes.
Just take what you want.
I'd second that.
Okay. Further discussion? I think I'm fine with up to 30 minutes, so I guess all those in favor? Okay, so the applicant will have up to 30 minutes. So with that, then, testimony and arguments presented must be directed toward the approval criteria or other criteria in the plan that the speaker believes should apply to the decision, as legal counsel said. The failure to raise an issue with sufficient specificity to allow the Planning Commission and parties to respond will preclude appeal on that issue. Because the applicant has the burden of proof, they will have first opportunity to present their case, and as we just voted, you will have up to 30 minutes. Yes.
I have a question. Usually it's the applicant speaking and then the person opposed, then a rebuttal. Does this mean the applicant will get 30 minutes and then a rebuttal period also?
There would be nothing to rebut, so he would just have his
So
time.
what was submitted as written testimony, he...
He can respond to that
We'll let
in
him
his
respond to that.
his presentation.
Okay, clear. Thank you.
All right. So the applicant will have a total of 30 minutes and may choose to reserve some of that time for rebuttal, but may not need that. And then, given the fact that Mr. Troutman is not here or representation, staff would then respond. And if any, entertain questions from the commission. And then finally, the applicant could use up the rest of your 30 minutes if you so desire. So when you come up, please give your name and address when you speak. And
Zach Mitke, if you please approach.
Thank you. Chair Randall, Commissioners, good evening. My name is Zach Mitke, and I represent Oakley Meadows Co-Housing. I'd intended to speak just briefly on a couple of procedural matters and then allow Mr. Troutman to speak. At this point, I don't believe that he or his legal representation is present, so I'll try and keep this brief. On the procedural issues, I'll just touch on those very quickly. As I believe staff alluded to a short time ago, the appellant has submitted materials from the prior LUBA record as well as briefing that occurred before LUBA and before the Oregon Court of Appeals. The applicant doesn't have any objection to the Planning Commission receiving those materials, with the exception of 3 different items that the Oregon Land Use Board of Appeals ruled were stricken from the record. And those are spelled out, I believe, on pages 11 and 29 of the LUBA decision. I believe that addresses that issue. In addition, the appellant, Mr. Troutman, has submitted with his testimony a series of maps as Exhibit A to his rather voluminous correspondence. Those are not materials that are included within the record either, and I would respectfully request that those be stricken from the record as well. Moving over onto the substantive side of things, the applicant has also, the appellant has also advanced a new argument. I believe it's on, let me make sure that I've got the page number where it comes up. I'm sorry, this is a very lengthy submission. I believe it begins on page 8, where the appellant contends for the first time that Oakley Lane does not have a 19-foot wide pavement. I would submit that that is an argument that was neither raised before the hearings official initially, nor included in the appeal statement that was provided to the Planning Commission initially. And so that is doubly barred testimony. And I would request that the Planning Commission give no weight to that and not consider it in rendering its decision. As the appellant apparently has not appeared or had his legal representation appear on his behalf, I'll move on into just a brief response to the materials that were submitted today. I don't really anticipate taking 30 minutes to do so, but I appreciate the Commission's offer of that time, and I'll be happy to answer any questions the Commission may have. The Oakley Meadows co-housing project.
Mr. Mitke, I know you're tall and the microphone is short, and I don't want you to hurt your back, but if you could, or even pick it up.
Right, and that's not a.
Everyone can hear you better.
Yeah, it's not an uncommon request, and I should really bring a microphone stand or something like that.
Thank you, Gabe. I just want to make sure everyone can hear you.
Yeah, and thanks for the assistance from city staff on that. The Oakley Meadows co-housing project is remarkable, frankly. It is a new experiment, I think, for the city of Eugene, but one that is well worth the accolades that it's received thus far and the support of the Planning Commission. It is a unique owner-supported project of individual housing units, which will also share common amenities. The unique design of the project has provided up to 50%, and I believe possibly in excess of that, in common open space, green space in the project, and with some really remarkable design elements. The City of Eugene has previously approved this project on 2 separate occasions, the hearings official and also the Planning Commission. We're just down at this point in time wrapping up a couple of loose ends, and I think that this is going to be a remarkable project once it gets off the ground. Despite the dense and voluminous correspondence that you've received and that I just saw today, I don't think there's actually much that needs to detain us tonight or detain the Planning Commission from reaffirming its prior approval of the project. Because the Commission's already addressed the central issues that Mr. Troutman has raised in his materials. With the exception of a single new issue that we talked about a little while ago, Mr. Troutman is merely rehashing old issues that the Planning Commission has already addressed and which LUBA has already affirmed in a prior appeal. To be clear, because this is an issue that crops up throughout the written materials, there's no problem with traffic safety on Oakley Lane. The Eugene Public Works has confirmed that the existing street provides safe passage for two-way vehicular traffic, bicycles, pedestrians, and emergency vehicles, and that there are no concerns related to traffic safety issues or poor service levels that would result from the proposed planned unit development. That's critical to understand because the appellant's testimony is premised largely on the concept that a wider right-of-way or more increased improvements are necessary on the lane in order to protect traffic safety, and that is simply not the case here. Now, most of the testimony is focused on the issue of the dedication of property for the future expansion of Oakley Lane. Section 9.6805 of the City Code permits the city to require dedication of a public right-of-way as a condition of development approval, provided that the city makes findings to demonstrate consistency with constitutional requirements. Recognizing that the PUD will provide a portion of the right-of-way to the city that will be necessary when the street is ultimately brought up to city standards, Public Works staff provided constitutional findings in support of an exaction of half the street width, that half that is on our client's property. We don't object to that. The half street width was selected because a southerly right-of-way line of an existing 20-foot dedication will form the center line of the street when it's ultimately divided or developed into a street that conforms to city standards. In these findings, the Public Works staff sought to establish, again, the constitutionally required findings, which are a requirement of both the local code provision and generally constitutional law. And as such, they talked about the nexus between the public need for the street development and the private dedication, or the dedication of private property, and the proportionality of the required dedication, and use the terms the risk if, sitting in terms of risk if the half-street dedication and a 13-foot additional dedication for a hammerhead turnaround are not dedicated. However, contrary to what we see throughout this rather lengthy document, Public Works did not identify any current safety need that mandates the immediate development of Oakley Lane to city standards. To the contrary, Public Works expressly recommended deferral of any improvement by an irrevocable petition for public improvements until such time as Oakley Lane as a whole was brought up to city standards and was satisfied with the existing street system to meet the needs of the neighborhood with the PUD in place. Oakley Lane is well below capacity at this point in time, even with the proposed development, even using very conservative numbers. They're never going to exceed capacity for this street section out there. It's simply not an issue. Opponents pointed to the Public Works findings in a desperate attempt to provide evidence of some traffic safety issue out there. There's just simply not one. Public Works was very clear that there's not an issue out there. So they pointed to this constitutional finding to say, well, you mentioned risk means safety. Safety means there's a problem. The hearings official was very clear in saying, I'm sorry, I understand your concerns, but concerns are not a problem. Risk is not a problem. And specifically what he said was assertion is not evidence, and neither is an explanation of inductive reasoning. You can't just point to, Public Works said risk, therefore there must be a safety issue. And going on, he said that the hearings official cannot substitute the neighbor's very strongly held opinions that more cars will necessarily decrease traffic safety for actual evidence. There was no actual evidence of any traffic safety issues, was entirely lacking. The Planning Commission, in hearing this appeal, lo these many years ago, agreed, noting that the Planning Commission finds that the constitutional findings in the Public Works referral comments are limited to justification for a proportional right-of-way exaction along the frontage of the property, our 22.5 feet, which we've agreed to and committed to providing the City of Eugene, that would accommodate future public street improvements. The constitutional findings address a future need for street improvements abutting the property rather than any immediate need, based on safety issues or otherwise associated with the proposed PUD. There's simply no traffic safety issue out there that would warrant a conclusion that the PUD will create a hazard. Accordingly, the appellant's claim that street widening or improvements are immediately necessary has no foundation, and most of this rather lengthy tome that you've been provided simply has no foundation. Well, we talked a little bit about the attempt to interject a new issue with regard to the width of the street or width of the developed street. That's simply not before you today. Even if you were to take a look at vicinity mapping or anything like that out there, the maps that have been provided, and I'm not going to suggest that you get into this area, are too indefinite to establish. They don't get down to a gnat's eyebrow. There's no surveying that's been provided indicating any kind of issue out there. So the less said, the better. The appellant also urges that the planned unit development will be an impediment to emergency response under the Eugene Code section 9.8320 sub 6, because he argues that off-site traffic will impede emergency vehicles. Specifically, off-site parked cars will prevent emergency vehicles from coming through. However, the Commission previously imposed a condition on our PUD to provide an emergency vehicle turnaround on our property to actually make the streets safer with regard to the planned unit development. And looking at the issue of emergency vehicles, again, there was simply no evidence in the record of a conflict between the parked cars and emergency vehicles accessing along Oakley Lane. But even if there were, the parked cars are not part of our planned unit development. It's not something the PUD is doing. The 9.8320 sub 6 is talking about whether or not the planned unit development itself will be an impediment to emergency response. Off-site vehicles, even if they create an impediment to emergency response, are not part of our PUD. Our PUD is providing increased traffic safety by providing the turnaround. It's providing additional parking spaces in the area, many more so than we're actually required to provide. And so our PUD will not be creating any traffic hazard. The appellant is also urging a strained interpretation of 9.8320 sub 5 that ignores the plain language of that provision in order to argue that Oakley Lane must be improved along its entire length. He's saying, well, if you want your planned unit development, you have to improve Oakley Lane from its intersection with River Road all the way out to your planned unit development. That's simply not the way that this works. 9.8320 sub 5 says, in order to determine whether a PUD provides safe and adequate transportation systems, you look at three discrete issues. We have established compliance with standards for streets, pedestrian and transit circulation, and traffic impact analysis review. We've already addressed all of that. We've already put that forward in our application. The hearings official made excellent defensible findings on that, and the Planning Commission endorsed those findings. And what's more, the Land Use Board of Appeals affirmed the Planning Commission's approval with regard to those findings. Again, there's simply no basis for this appeal. Again, I'm just going to recommend that the underlying decision be affirmed. I don't believe that I need have eaten into 30 minutes at this point in time, but I'm more than happy to answer specific questions or general questions with regard to the application.
Are there questions from the commission? Okay, thank you, Mr. Mickey.
Thank you.
Does staff have a response?
Not at this time.
Okay. And are there questions of staff from the commission? Commissioner Borowski.
Yes, Zach mentioned that the evidence in the testimony that we received this afternoon regarding the right-of-way width of Oakley Lane, he asserted that that would be new testimony. Can you give me a take on that, please?
Yeah, we're basically in agreement with applicant's position on that. There were 3 different exhibits that were attached to briefs that were submitted at LUBA, and either the applicant or the city objected to those 3 exhibits or attachments as outside the record, and LUBA struck all 3 of them. And those are the 3, well, I guess he's talking about those 3, but then he's also talking about the aerial photos that were submitted in the packet today. So he's proposing, at least I understood him to be proposing, that all of those be rejected as new evidence, and we would agree with that.
Okay. Second question that I had was in regards to the right-of-way that is being required at the Oakley property, the 45 feet total. In Mr. Troutman's testimony, he asserts that that needs to all be included, not just the half on the Oakley side. What is the staff's opinion on that?
Well, I think it's a matter of practice that when we're looking at a right-of-way exaction, as part of a condition of approval, that we're looking at the half of the right-of-way on the applicant's side of the center line in terms of what would be their proportional dedication as a result of the impact. And so that's what the condition effectively does.
There is, I'll just add that there is, this issue it was one of the big issues on the LUBA appeal. So there is, if you do decide to take in some of the briefing without the evidence, there's a pretty clear explanation of how the city processes these things and why what we're proposing to do is within the practice and actually pretty much what's required based on takings law.
Okay.
Commissioner Jaworski.
Yeah, I'd like to follow up on what Commissioner Borowski said in more of a form of a request. You have already indicated several items that might be not considered or excluded, and the applicant himself identified, I guess in a semi-rebuttal, it wasn't clear, but he identified some issues raised that should not be included. This is a pretty extensive amount of material submitted. What I would like is if as soon as possible staff might just send something saying these are the things that probably should be excluded so that we don't have to waste a lot of time reading things or get an imprint in our mind of something that we shouldn't have considered.
Yeah, I would definitely, was already thinking about doing that and explaining to you what the code says regarding official notice and what the city attorney has advised in the past about why things should or shouldn't be accepted as
yeah, but even and identifying the ones
and identifying
that
the things
yes,
that you
okay.
might want to reject because they're new evidence.
Okay, thank you.
So if we do take official notice, how would we word excluding? Would it be we take official notice excluding the items that
so
you determine or not?
Yeah, the opponent has filed a motion basically for you to take official notice of all of the LUBA briefing, and then you could say we will take official notice of all except these, and then identify those items that you're not taking official notice of.
But if we don't yet know all of those items, how would we do that?
If you don't know what all those items are,
Right.
oh, you will need to know what those items are.
Yeah.
And
So I'm wondering if you're going to get
Yes.
us that information
I will
would
be
word
there either 3 or 7 pages of things that both the applicant and I have identified as things that are outside the record, and I will identify those, and then it will be up to you to decide whether you agree that those are outside the record.
We need to take a notice during this hearing, or can we do that during deliberations?
You can do that during deliberations.
Okay. Now
And I would suggest you do that because you'll be able to have time not only to look
now I
through
feel
the...
better.
Yeah.
Yes, thank you. Okay. Commissioner Borowski.
If that's the case, that we decide to look at things but exclude some things from the record, would the opposite side have an opportunity to show where they believe that they are in the record?
So the way, okay, so it's the opponent who is arguing to take official notice of. It's basically that binder
Yeah.
up there. The applicant has identified their 5 things that they object to. So I think what the applicant has said tonight is they don't object to taking in the briefing. So that, we're agreeing, doesn't have any new evidence in it, so there wouldn't be any requirement that you provide rebuttal or response to the applicant for that, as long as you take the new evidence out. If you do decide to allow some new evidence in, and he requests to respond to that new evidence, you would have to honor that request.
Commissioner Baker.
Yeah, a lot of the applicants and the appellants' concerns are regarding this Public Works report. Can you highlight that to us? I'm sure I have copies in my. But if you could highlight to us what page that, where we would find that easily, so we don't have to. I read through a lot of material this weekend, but I can't remember. A lot of times things gets repeated a lot.
Right.
But the original
Public Works report.
Yeah,
Yeah. And there was, again, in the LUBA briefing, there was arguments that identified the Public Works and identified the hearing special decision. It explains that, so I could point out the briefing if you wanted to look at that too.
And I had another question that follows up on Commissioner Borowski. I'm trying to figure out how the half of the right-of-way at the end of the street provides a turnaround. I mean, if that was deemed important for emergency vehicles, how does that?
Can answer that.
Based on my recollection, it's actually provided on the subject site, not within the right-of-way at the end of the street.
It provided an additional one.
Yeah.
What I recall.
So through an emergency turnaround easement that overlays the access within the development site, they'd be providing that
And I believe
opportunity
that
for.
could be something we look at during deliberations,
Yeah, that material's in the record.
because that is in the record.
Yeah. Well, it would be useful if you could, again, highlight that for us. So
I would recommend looking at the site plans for some of those.
make certain that that's not something that was just proposed, but is actually required, a mandatory requirement or something.
I think it was a condition of approval too, wasn't it?
Yeah.
Yeah, I believe it was a condition.
Okay. Commissioner Borowski.
All right, sorry about this. Okay, so Ann, you mentioned the fact that we could reopen the record. What can we reopen the record to allow in?
So, okay, and this is something that will be much more helpful for me to do a legal memo on, but, so the code provides that you can take official notice of certain things. Do you have that here?
But official notice does not reopen the record.
You don't have to reopen the record, but it's
Right.
similar to reopening the record. So you can take official notice of the following. This is 9.7095 of the Eugene Code. All facts which are judicially noticeable, all public records of the city, and the charter, ordinances, resolutions, rules, regulations, and officially promulgated policies of the city. So the argument that the opponent is making is that the LUBA briefs that were prepared by the city and in the hands of the city are public records. So you can take official notice of those public records.
Right.
So the advice that the city attorney has given the planning commission in the past when they're doing appeal hearings where their review is limited to the record before the hearings officer is this provision allows you to take official notice of a whole lot of things that might include new evidence. So they've cautioned, we have cautioned you about reading this very broadly to allow any kind of public record in. So that's why I say you can look at certain things that are public documents that might be new evidence, but you're not required to.
But that's not what I asked, because you mentioned that we could open the record.
Okay, well,
All right,
I
and
might
so what
have misspoken then.
Okay, so what I heard was you can open the record and allow, we can look at that without opening the record, or we can open the record and allow that in.
Yeah, I think I meant to say you can take official notice of it, not opening the record, but you can choose to bring in that material.
So we don't have an option to open the record for new evidence.
So, okay, LUBA gives broad discretion to the city on remand. So the rule is a local government can do a lot of things on remand. Generally, what they want to do is remedy the error that was committed that led to the LUBA appeal.
Right.
So the Planning Commission could, if it wanted to, decide to, for lack of a better word, blow it open and open this up for all sorts of new evidence.
Okay, that's my question. So that is a possibility. What are our time frame constraints if that were to happen?
The time frame constraint is on remand. The Planning Commission has to act within 90 days of when the applicant requested that the remand be initiated, which was July 13th. And I have a date in your memo, which I think is October 12th or something.
Yeah. Okay.
So you have to take your final action before that 90 days runs.
Okay. And normally, if you open the record, there's time for the record to be open, and then time for the applicant to
Other side to respond to the new
respond to
evidence.
that,
Yeah.
but not another one to respond to the respondent.
Yeah, so if there's, what I generally suggest is you have the first opportunity for all parties to present evidence, the next 7 or 14 days for both sides to respond to that evidence, and then the last opportunity for the applicant.
Okay. Okay, so the reason I'm bringing this up is because we've got interested parties on both sides here. Obviously, this is a contentious issue. It has been for years. And I just want the commission to have all its options available so that we have the ability, just so that we know that we have the ability to open the record all the way back up to receive new testimony if we feel that is the appropriate response. So I just want to know what we have, what cards we can deal, and then it's up to the commission to make a decision on how we want to deal those cards. But the way it was presented, I just want to make sure that we have all the opportunities, because this is like I said, it's a contentious issue. We've got half the room here on one side and half the room on the other side. And I think it's our duty to do whatever we can to make the best decision and the most non-appealable issue.
Luba-proof.
You would come up with the best findings that we can that will move this process to a conclusion one way or the other.
Commissioner Baker?
Yeah, I want to follow up on Commissioner Borofsky's comments. There were two things that struck me about this compared to what we've normally had to deal with in the past. One is we missed notice, and we missed notice not to just one person, but a number of people, but one person complained. That bothers me that we missed notice, because we have a strong interest in making sure that there's community involvement in all of our deliberations. And the second thing that struck me was the Court of Appeals statement, which said they just threw it out because of the first case, so they didn't bother to consider the others. And that's troubling to me, in that we could bounce back and forth here because we didn't consider all of the evidence that they might, for whatever reason, consider that we didn't. And it'll go back through LUBA to the Court of Appeals and then back to us on a remand of some other issue that we didn't fully vet and cover in our findings. So that disturbs me. Anyway, I just wanted to state that.
I have myself in the queue, and then Commissioner Jaworski. And I guess the way I take a little different view of that, and that even though some people were not given notice originally, they have since been given notice and have had opportunity to respond. And I guess we've had public hearing before the hearings official, public hearing before this body, and now this limited public hearing. And I guess I'm not sure that reopening blowing it open, as City Council said, is in anyone's best interest. Commissioner Jaworski.
As I understood it in staff and in the documents that I received, LUBA pretty much approved of everything except the southeast screening or the east side screening and the notice with Mr. Troutman. Since we spent a lot of time in deliberating on this, I was on the commission when we deliberated on this, and so they didn't find anything wrong with those findings. I just want to reiterate that and probably try to expedite this. Based on what's usually happened, and since there was no request from the applicant to keep the record open and to finalize this discussion, I would move that the record be closed.
Okay. Is there a second to that motion?
I second.
Okay. Moved and seconded to close the record. Do we have discussion on closing the record? Yes, we do. Okay. I saw hands here. I'm going to go Commissioner Mills, then Commissioner Baker.
I guess I would just basically support keeping the record closed. I have a concern about meeting our deadline requirements if we open the record, and have to address basically opening it up and expanding the breadth of what we're trying to do here. And I feel that Commissioner Jaworski's point about what LUBA has ruled and what remains to be addressed is pretty clear, and I think we're taking care of one of those things tonight. So I'd be for keeping the record closed.
Okay. Commissioner Baker, then Commissioner Borowski.
Yeah, I was actually hoping that we wouldn't fully open the record, but we would accept the attachments, the new information. For example, the narrower street width, as an example.
I think that's a separate issue.
Pardon? No, but the point is, rather than opening the record, we just accept the statements, and that allows the applicant to rebut that, but it doesn't fully open the record where you have to accept everybody else's new testimony. Because my concern is, we've allowed Mr. Troutman to participate, but at an expensive cost. Someone has paid for lawyers and so forth to go first to LUBA and then to the Court of Appeals because we didn't notice him properly to begin with. Wouldn't have cost him anything to testify in front of the Planning Commission if he knew about it. And that bothers me. That really bothers me. That and now we're saying that's fine, and we may end up doing it again. If this person wants to appeal, they'll appeal it, and it'll go to LUBA, and then it'll go to the Court of Appeals, and then we'll find out what the Court of Appeals says, and we'll decide whether the additional information that was provided at LUBA will be considered by the Court of Appeals. If they decide to accept it, then we're back where we're back where we are again.
Do you want me to?
Could
I'll just
counsel
say,
respond to
my belief of how that would play out is if you chose not to take official notice of those documents, which you have the discretion to do under your code, it would be pretty hard for LUBA to overturn that because
That's a separate issue. I only moved to close the record. I did not act on the official notice.
That was my question.
I made that clear. You had even said they're two different things.
Yep.
So I'm only closing the record. That's another discussion for
well,
someone
I think
else.
he was.
Yeah.
I think he was kind of addressing that in a
Oh,
tangential way.
and
Third cue.
Okay.
in regard to, I'm sorry.
I'm trying to keep us on track here. Commissioner Borowski's next, then Nicolello, then
And this
Commissioner
may help
Jaworski.
get us there. So I have a question for council. If this motion carries, would we still be allowed to take notice of the LUBA, the thing that Mr. Trotman brought
Yes,
up?
I believe that you could. So, and this is what Gabe just mentioned to me is, so if you play it out and you close the record now, I write you a memo that says this is what official notice means, and you decide to take in that new material,
You can or take notice.
you may need to reopen the record to allow the applicant to respond to that new evidence.
Okay. So there is still a possibility to take notice of the LUBA decision, less the new,
Yes.
the new
Evidence.
new material. Okay, then I can probably vote at least on, I don't know how I'll vote, but I can vote on that without making an amendment to it. The second thing that I'm having difficulty with is the fact that the city sent me a document this afternoon that it knew had new evidence in it. And that may have prejudiced me
Well-
because I went through that and said, this is new evidence, or this is stuff, and you shouldn't have sent it without vetting it, in my opinion.
Well, can I respond to that?
Yes.
I did look at that, and Gabe and I talked about it. I mean, I take the approach that it's basically the Planning Commission's, I know this is not how it's been done in the past, but it's the Planning Commission's opportunity and job to make that determination. So it can accept in evidence, but I think it's the Planning Commission's job to then reject that evidence and to make that determination that you're not going to consider it. We may want to have a discussion in the future about whether you really think that's my job or not, but my position is that the Planning Commission's job is to do that.
So it's our decision to decide whether or not,
Based on my advice.
based on your advice, whether or not what the applicant said was new evidence is new evidence.
That's my belief.
All right.
Commissioner Nicolello.
Commissioner Borowski and I actually had similar questions, so thankfully he answered mine. But I just want to maybe, just to be on the safe side so we all understand the options in front of us and the phases in which we must vote on these options, can you please just one more time lay them out in the simplest layman's terms that you can, what our options are and in what procedure we need to do them, just to be very, very clear.
Okay.
And then I will have a follow-up to that.
So what we're dealing with first is what I call the Troutman hearing. You're also, hopefully tonight, also going to be talking about the landscape screening issue that we're trying to keep separate and we've been able to do so far. So we're talking about what's the Troutman hearing, the procedural glitch that happened, and we're trying to correct that. So what we've got is, do we close the record or do we not close the record? And we have this issue with the official notice. So that's what I see as the things that you need to grapple with. The official notice issue, I'm advising you to not necessarily have to decide tonight. You probably want to figure out what you're doing with closing or not closing the record. Is there any follow-up?
That is, you explained that perfectly. I think I just wanted to make sure that, so we were on the same page, so we can choose to vote to close the record or not close the record tonight, and then in deliberations on the 17th, that is when we can decide about the official notice.
Yes.
That being said, I know that there have been some concerns over the fact that there was misnotice to several people, but those people were still notified along with Mr. Troutman, so my concerns are alleviated on that. Although I am sympathetic to the fact that they did have to endure legal hurdles to get there. However, that's outside of our jurisdiction. I think also, too, from my review of the public record, I don't think that opening it would provide really any drastically new information. And I think that at this point, what we really need to do is, I think that it's time to close the record, and then I think that we need to go into our second thing of trying to address the landscape screening issue, because that is what LUBA has deemed to be of our primary concern at this point. So,
Commissioner Jaworski?
Since we're still in the discussion of the original motion, I just wanted to bring up a possible clarification of what was raised during that discussion under potential appeals. If I understand this correctly, since we allowed Mr. Troutman, since he was prejudiced, to present testimony, and we're considering it, then the only really appealable item would be whatever we decide on the landscape screening, because all the rest has been addressed. Is that not correct?
One would hope.
Huh? Okay.
Commissioner Mills?
I just want to make sure I'm understanding clearly about Mr. Troutman's testimony. It is now in the record?
The testimony, you have not yet
I know
determined.
that's a pretty stupid question, or
Right.
fundamental.
So when something goes to LUBA, what's considered part of the record is what's been accepted and not rejected by the
Okay,
Planning
so we
Commission.
have-
So you have not yet determined whether you've rejected certain things.
Okay, and so if we have to make that determination, I guess one statement I would make about that is one of the reasons we were directed to hear testimony was to hear testimony. And I think that I'm a little concerned about the idea that we might hear something that we haven't heard before, or seen something that we hadn't seen before, because I think that's the purpose of the testimony. So I'm a little, because we missed on the process in the beginning. I guess we missed a step. Therefore, we left out the possibility of introduction of some evidence that should have been introduced. So now we can't come back and say, well, we're not going to hear anything new. It feels like a little bit of a circular argument there. If we're saying, okay, we'll hear new testimony, we'll take into consideration what Mr. Troutman says, but we're not going to hear any new testimony. Because of our flawed process, we missed testimony, and now we're saying we're not going to hear it.
The first time, well,
I just want to make sure I'm
there's confusion
clear
about
on
what
what-
testimony and what evidence is. I mean, you can testify and make arguments.
Well, I mean, for example, the road map, the map that the applicant is saying,
Yeah.
oh, this is new evidence. Well, yeah, okay, it's new evidence. It might have been presented when he had it.
Well, you wouldn't, because it was limited to the record before the hearings officer at that point.
Right.
I'm sorry, say that again.
So anyone who testified at the first Planning Commission hearing
Mm-hmm.
was also limited to what the record was before the Planning Commission at that time.
Okay.
So that's why we're
That
trying to
maybe
keep
could
it
have
the
been
same this
introduced
time
at the
around.
hearings official
But not
stage, but not at the appeal. And I guess I
Understood.
have.
Okay,
Oh,
go ahead.
sorry.
Go ahead.
I didn't- Are you done?
Yes.
Okay. And I guess my question is, the testimony that we received, even though it wasn't verbal, it was written, and by closing the record doesn't preclude this from getting into the record sans whatever is new evidence.
Right. I think you can close the record and then in the future decide. Is that what are you saying?
Well, I guess I want to make sure that if we close the record and we haven't officially said, yeah, this
Yay or
is
nay.
okay, that it doesn't just
Go
leave
through
it out.
You can, in the future, we can deal with
When we get
rejecting
into
it.
deliberations, we
Yeah.
can adjust that, because you still need to look at it to make sure what is or isn't new
Right.
evidence. Okay,
And that would be the official.
yeah. Commissioner Borowski.
Okay. Speaking to the motion, considering the time frame that we have coming up on this, it would be my recommendation that this body make a decision on whether to take notice at this meeting. So, because if we decide to take notice at our deliberation meetings, I'm going to not deliberate until I read the record. So I would like to at least put that before the commission. If we're going to wait until the 17th to decide whether or not to take notice on that, that may push us back another, and as full as our docket is. So I think that we need to have the discussion tonight about whether to take notice of the LUBA appeal with the redactions that the have already been brought up as being new evidence. And the city attorney seemed fine with that, and the applicant seemed fine with that.
Commissioner Jaworski.
Yeah, I'd like to move the question so that we can get into talking about the things that we're getting into, which is official notice. We could take that up after we voted on this.
Okay. We ready to vote?
Can we restate it, please?
Yeah. Restate to close the record,
I had moved that the record be closed.
and that has been seconded. All those in favor of closing the record? Opposed? Okay. Motion carries 4-2.
I would like to make a motion.
Okay.
I'd like to make a motion to take notice of the, how should I put it, the LUBA, or the, whatever the.
I would call
how
it
did
the
he-
attachments to the opponent's submittal.
Yeah.
Okay.
And less new evidence identified by the city attorney.
I'd second that.
Okay. Is there discussion on that motion? Okay. Commissioner Nicolello, then Mills? Sorry. Okay.
Just as a, sorry, let me turn this. Just as a clarification, are we also including in that the 19-foot wide pavement that was discussed earlier in the applicant's response?
Not in this motion. This motion is to,
That's not in that information. That's in
Okay,
this.
I just wanted to
Yeah.
clarify.
Yeah.
Thank you.
this is further down. It's on page like 30-something.
Commissioner Mills?
Entrapment
I
submitted.
guess I'm a little fuzzy on we're asking that we take record of, and I understand the time frame. How does staff feel about this? Are you comfortable with that wording? So we're going to accept something that we don't know what we're rejecting yet, but we're going to trust you to come up with a list, right?
I think Luba kicked it out.
Luba redacted some, I think. Is that what I'm understanding?
There's
Okay.
there's something else that the applicant objected to.
Right. Okay. So it's been moved by Commissioner Borowski to take notice of the attachments to the testimony tonight, and I don't remember if there was a second. Commissioner Jaworski seconded. Any further discussion? All those in favor?
To be clear, the motion includes, as I understand it, those items as attached minus whatever the city attorney
Yes,
recommends be rejected in a memo that's forthcoming.
Yes.
That, okay. So that is correct on your motion and your second, that it's, okay. Got that? Okay. All those in favor?
There's a discussion?
We had discussion.
Okay. I just had a
I asked if there was other discussion. Okay. Okay. All those in favor? Okay. All right, motion carries. Is that all we need to do on this particular issue tonight?
I'm not sure if you've closed the hearing yet, but if you
Oh,
haven't, you should do that.
no, I guess I do need to close the hearing. Okay.
I had a question.
Okay.
The attachments, is that the same as the brief, the LUBA brief that was presented to the Court of Appeals?
The attachments, I think, include the LUBA briefs, some of the LUBA briefs, maybe not all of the LUBA briefs, and some of the Court of Appeals briefs. I'm not sure if it's all of the Court of Appeals briefs. So that folder is my copy of all the LUBA briefing that went to the Court of Appeals. I think he
I believe
attached
that's
his
the
attachments to the
3
Court of Appeals
volumes
brief.
in the electronic files we received.
Yeah, and I've also got a disk here with all of the attachments that we're referring to.
But there are attachments that are in here that won't be, like the Oregon maps was one of the attachments, and I think that'll be one of the excluded ones, correct? Thank you.
Well, I think that's in Mr. Troutman's testimony,
that's
not
different.
in the,
Oh,
because
but
the
that's what
LUBA
he was asked to
Yeah.
put in.
The LUBA, the 3 volumes of LUBA briefs are one thing, which we just took notice of. Mr. Troutman's testimony, the 50 whatever pages, is what we're going to look at during our deliberations to determine if there's anything in there that's new evidence. And the city attorney is going to help us with that. Am I stating that correctly?
I think it's both.
Yeah.
Hold on a second.
see where this says it.
At least that was the way I was understanding it. Because I know, Sid, you haven't had this very long either.
No.
I mean, none of us have. It's dated yesterday, so.
Yes. So, as much as I can gather from the times that we've had, there are attachments that are LUBA briefs and Court of Appeals briefs. There's at least 1 or 2 or 3 documents in there that LUBA rejected because they were new, and the applicant has objected to those. There's also about 7 or 8 aerial photos that aren't in the attachments, I think, that are part of the testimony that Simon Troutman submitted. I don't know if those are part of the attachments or if they're part of the letter.
They're part of the letter.
Both. They're actually in 2 sections.
Okay.
But again, we intend to provide a memo that will clearly list
Right.
out those items that the city attorney recommends that you reject, and we'll do that soon, within the next week.
Because our deliberations are scheduled for the 17th, so we have time for them, for staff to, city attorney to give us
bring
that help.
clarity to
and
that.
then be able to know what to review and what not to review. Okay. All right. Question?
Yeah, before we move on, I just had a question I just want to ask because I want to make sure that I understand this. You mentioned that Court of Appeals and its deliberations could consider what is considered in the public, or some phrase like public record.
It's not a LUBA rule, it's what the Planning Commission or a hearings officer before the city can consider can take official notice of.
Okay. And would street ownership, property, would that be considered public, in other words, public record information?
If there is a document that shows that, there has to be a specific document that's a public record in order to qualify as a public record under
So
that
it's not like you
provision.
could go through, and if you could go through and find that information and compile it, that's different than taking notice.
Creating a new document.
Yeah, my main concern is that if the Court of Appeals may accept information on street ownership and we don't consider it, then,
Neither LUBA nor the Court of Appeals can accept new evidence during their appeals process.
right, it's the question of whether that's considered new evidence because it's public city information. You'll follow what I'm saying?
But the Planning Commission needs to make that determination, and it's a discretionary one based on the code provision that she read to you earlier.
Right.
And based on that discretion, if the commission decides to bring something in, then that would be part of what they consider ultimately on appeal.
Can't you close the hearing now? We still ask questions.
We did close the hearing.
It is closed.
Yeah.
Okay, good.
Commissioner Brodsky.
Hearing is closed.
Okay, my question is then, by taking notice of what they're the applicant.
Opponent.
The opponent, thank you. Of what the opponent requested. Are the maps in question a public document? Because they're listed as Oregon something.
Or map.
Where is it? Give me that code provision again,
I'm trying to find it.
the public record one.
Because if they're a public document, what I understood from you was saying was that we have the ability to take notice of public documents that are available. And the opponent asked us to take notice of those public documents.
Okay, so you're talking about the aerial photos? Okay, so these are aerial photos. I don't know where these came from. The code provision says all public records of the city. So I don't know if this is a public record of the city.
Okay, would you look into that as part of your excludatory? That's not a word, but
I know what you mean.
It actually looks like just an aerial photo offline. Off
well,
the internet.
but at some point the tax lots are drawn in.
Tax
So
box,
Okay.
it looks like Orland, actually. is what it looks like.
Okay. Commissioner Jaworski.
Yeah, I keep getting more confused as we move forward. It was my understanding that whatever testimony was presented, either orally or written today, was still confined to the fact that it was during the appeal process and it had to be limited to what the hearing official heard or was part of that record and not to include other items into the record. Is that not correct?
So the question was asked by Commissioner Borowski is, do we have the authority to, as I said, blow it open, for lack of a better word? And so what I've explained is LUBA says that the city has broad discretion to determine what is appropriate for it to do on remand. What we tend to try to do is we try to narrow the focus into correcting the error that happened. And so that's what we're trying to do, is we're trying to allow Mr. Troutman to get back into the position he would have been in, which includes limiting it to the record, which the other parties were limited to on the first appeal. So Commissioner Borowski said, well, could we open up the record? And I said, yes, you can.
Well, we already closed the record.
Decided to close the record, though.
It has been closed already.
Yes.
I think the question is, I'm sorry, I'm interrupting you.
No, that's okay. I just feel that if those were presented by Mr. Troutman, as I understand it, that everything that relates to what was in the prior record could be included. I didn't get the impression that we're allowed to look at that and add new things to the record that wasn't even considered by either the hearing official or during the appeal.
And I think that's a correct understanding.
Okay, thank you.
except for the take notice.
And again, new evidence is different than taking official notice of records of the city. They're two distinct things, and we'll be providing you with a list of those things that we think you should not consider.
So again, I think legal counsel will be letting us know what, in your opinion, is information that is not in the original record.
Or is in the city,
Okay.
is in the city's
Of
record.
those, yeah, I'll answer
Yeah.
those questions
Okay.
separately. This is the city public record.
Okay. The next item, we're going to put the remand hearing aside now and move on to the other issue that was remanded to us by LUBA, and that is the remand of our previous decision regarding the landscape screening on the eastern boundary of the property. And what I'd like to do is tonight limit that to just the process of how we do that, so that that can be part of our deliberations on the 17th also. We have a memo from council that explains that the LUBA decision did not specify what procedures are required in our consideration of that issue, and that memo outlines three separate options. One is to conduct a hearing that will allow participants to present new evidence and argument about the amount of landscape screening necessary on the eastern boundary of the property. Two, do not allow any new evidence or testimony, render a decision on this particular approval criterion based on the record that was prepared during the proceedings prior to the LUBA appeal. Or three, open the record for written testimony only to allow the parties to present new evidence and argument regarding the appropriate level of landscape screening. And I guess as we look at this, I think it's highly dependent on balancing that legal risk involved in each option. So I would suggest as we discuss each option, we consult the city attorney again on outlining those legal risks. And maybe, okay, Commissioner Borowski.
This just goes for a informational question to anybody who can answer it. This deliberation was quite a while ago, and this decision was made by us to not require the screening. Can you refresh me as to why we made that decision, or where? I mean, I watched about 1.5 of the deliberations is what I got through to, and I couldn't remember finding it, and I didn't have my notes as to why we did that. I remember there was one section of the area that had cedar trees, and we didn't want to encroach on the roots of the cedar trees, but that's on the north side, so I don't recall the east side.
So along the east boundary, in essence, toward the river. The issue relates to approval criteria in the PUD that require adequate screening.
Right.
And initially, the applicant made the case that they ought not to have to provide that based on their desire to have an open view in that direction. I believe staff originally supported that recommendation based on a variety of factors. The hearings official, in reviewing that in the initial proceedings, determined that the criterion required a condition of approval for some form of screening to be provided, and that condition refers to the code provisions at 9.6200, which spells out the different landscape treatments that are typically required within the code. On appeal, Planning Commission ultimately determined through its deliberations to remove that condition, and I believe, in essence, agreed with the applicant.
Okay.
And so, on further appeal,
Right.
Luba
I
determined
understand that. I couldn't remember the deliberations on that and why we came to that decision. And it would be helpful to me for our deliberations on this if you could find that on the, at what point this came up, so that I could go back and refresh myself with the arguments that were made at the time.
Commissioner Jaworski?
I have two things. One is, was there anything that you had a chance in the brief time to look at that maybe Mr. Troutman put in that would be new evidence to the screening on the east side? Did he speak to that issue?
I think it was all transportation. I don't think that there was any vegetation screening at all.
Possibly in a response to Commissioner Borowski, I was part of that group that went through that, and at the time the map was pretty broad, and I feel there may have been a misinterpretation after reading some things that have been said, but there are some trees that are further away from the property that are public, and I guess what they were saying is that it's not for the public to do the screening, it's for the applicant to do the screening to the public. So I can understand. I'm just trying to say that he may not see that in the videos, but I wanted to let him know what was on my mind when I was looking at that, which may have been an error based on the definition of what screening is and who does it.
I had myself in the queue
Go
too,
for it,
but
go
go
for
ahead.
it.
Okay,
I was just going to add to that, very briefly, in that you made a very good point in your AIS about that keyword "from" that's in the code.
So just to jump in here, I think it's important that we first decide on the procedure that we would consider the issue under, and I'm hearing you creep into some of the substance of the issue, so I had to caution against
and I guess
that.
that's what I was going to bring up, and I guess for me the question is, do we feel there's adequate, as far as reopening the record or public hearing or whatever, I think our decision tonight is really, do we feel there's adequate information in the record already to make a decision in response to Luba's remand? And I think from my perspective, I think there is. I think there's plenty of information in the record to do that, and so I would lean toward not reopening the record for that. So I have Commissioner Mills and then Commissioner Baker.
2 points, I guess. I'll say that again. I think that one of the things that I think I missed during deliberations was that the phrasing in the code that uses the term "from," shielding the development from the public, and I think that might have slipped from my mind. As far as which option, and I'm in support of what Chairman Randall has stated in terms of there being abundant information in the record, and I believe that we can do not need to reopen the record, and we can address it. I guess the short terminology is option 2 is good for me.
Commissioner Baker.
And I was just going to ask staff and legal counsel, what would be the recommended mechanism of the 3 that would hopefully prevent us from seeing this remanded again?
So conducting a hearing, I think, is way more than what you could possibly require. You're stuck with 2 and 3, really. It's how I see you deciding this. I think either could be defended. Either would be Luba-proof.
2 or 3?
Yeah, 2 or 3. So if you decide to close the record, I think that's defensible, and we could defend it at LUBA.
I guess from my perspective, I haven't heard anyone or any indication of wanting to reopen the record for written testimony, but I would entertain a motion. Commissioner Jaworski,
I move option 2, that we do not reopen the record.
for a second.
I'll
Is
second.
there a second? Okay. That's okay. Okay, it's been moved and seconded to accept option 2, which is to, and I'll just reword it here, is to not allow any new evidence or testimony, render a decision on this particular approval criterion based on the record that was prepared during the proceeding prior to the LUBA appeal. So it's been moved and seconded. Discussion? All those in favor? Okay. Motion passes unanimously.
Yeah.
And I think,
Are there any other questions that we would have for
any
staff?
other questions of staff, I think, from the commission? We've already
So
closed
I
the
will get
hearing,
you,
so, yeah.
staff and I will get you a memo as soon as possible in
good.
preparation for
Thank you.
your August 17th deliberations.
Thank you. We're adjourned.